Hello, lawyers and learners. Let me begin with a question today. Suppose two adults are in love with each other, their families approve, and with mutual consent, they exchange garlands. They take photographs, they go to a marriage registrar, and they obtain a certificate. Now, ask yourself this question. Are the couples married in the eyes of Hindu law? Most people outside a law classroom would say, of course, yes, there is consent and there are photographs and there is certificate. But as a lawyer, we cannot stop there. In Hindu law, the real question is not simply did the society treat them as married. The real question is whether a marriage existed as per Hindu Marriage Act 1955. That brings us to three questions. First, who can marry? Second, how must the marriage take place? Third, what happens if the law is not followed? Today, we are going to study the essential of valid Hindu marriage with focus on Section 5, Section 7, and Section 17. Section 5 gives us the condition of a valid Hindu marriage. Section 7 tells us about the necessary ceremonies. And Section 17 tells us about consequences of bigamy. So by the end of this lecture, I want you to be able to answer a simple question from the law point of view. When can we say that a Hindu marriage exists? Not in the eyes of society, but in the eyes of law. That is the point of inquiry today. So let us now begin with the roadmap for this lecture. Whenever you are asked whether a lawful Hindu marriage exists, you must not talk about the marriage certificate. You should also not talk about marriage ceremonies, invitations, photographs. You should start first with the statutory test of a valid Hindu marriage. There are three questions I talked about. Those questions shall first be answered. The first question being, who can marry? That takes us to the capacity and conditions under Section 5. The second question is, how must the marriage happen? That takes us to the ceremonies under Section 7. Lastly, the third question is, what if the marriage fails the legal test? That takes us to the consequence, such as in case of void marriage, voidable marriage, or even for that matter, the punishment for bigamy. We will not merely look at various possible defects in Hindu marriage. We will connect every defect with its consequence. If I were to give a mathematical formula for determining a Hindu marriage, it will be something like this. Valid Hindu marriage is equal to capacity plus statutory conditions plus lawful solemnization, that is ceremony. In ordinary conversation, people use the word marriage very loosely, but in law, marriage involves fulfillment of necessary condition as per this formula. But the Hindu Marriage Act gives legal significance to the idea of solemnization. The Act does not treat Hindu marriage as a private promise between two individuals. First of all, there must be at least one party that is governed by the Act, meaning that at least one party to the marriage should be Hindu. There must be compliance with Section 5. There must be solemnization as per Section 7. And if any condition fails, the consequence must be identified. Now we enter Section 5, which we can call as the entry gate to Hindu Marriage Act. It tells us legal requirements to be fulfilled by the parties to the marriage under Hindu law. It gives total 5 conditions. First, neither party should have a spouse living at the time of marriage, meaning bigamy is not allowed. Secondly, the parties must have the mental capacity required by law. That is, parties must be of sound mind at the time of marriage. Thirdly, the bridegroom must have completed 21 years of age and the bride must have completed 18 years of age. This particular condition is also in congruence with the Prevention of Child Marriage Act of 2006. Fourthly, the parties must not be within prohibited degrees of relationship unless custom permits. And lastly, the parties must not be Sapindas of each other, again unless custom permits. Now Section 5 must always be read with section 11, 12, 17 and 18. Section 5 gives us the conditions and the latter provisions tells us the legal effect. If section 5 conditions are not met, then the consequence of it are given in section 11, 12, 17 and 18. Let us now take the first condition, that is neither party has a spouse living at the time of marriage. This is the statutory monogamy rule. Before codification, Hindu law permitted polygamy, but the Hindu Marriage Act made monogamy the legal rule. Now, if one party already has a living spouse and contracts another Hindu marriage, Section 5 subclause 1 is violated. Let us understand what is the consequence of polygamy in Hindu law. Section 11 says that such a marriage is void if it contravenes Section 5 subclause 1, 4 or 5. If these three subclause, that is subclause 1, 4 and 5 of section 5, if they are violated, then such a marriage is void marriage. The section 17 then connects the situation with bigamy. But for criminal bigamy, the second marriage must be proved while the first marriage persisted. We will also talk about the burden of proof involved in allegations of bigamy here. Let us now understand monogamy through two important cases. First case is of Yamunabai Anantrao Adhav versus Anantrao Shivram Adhav. The facts are very important. Yamunabai married Anantrao in June 1974. The marriage was performed by observance of Hindu rites. But Anantrao was already lawfully married to Leelabai, who was alive and whose marriage with him was subsisting. Yamunabai lived with Anantrao only for about a week and then she left alleging ill treatment. Later, she filed an application for maintenance. The legal question was, can a woman whose marriage is void because the man already had a living spouse claim maintenance as a wife? The court held against her under section 125 of CRPC. This was because for that provision, she was not treated as a legally wedded wife. Her marriage was void because it violated section 5 clause 1. Now think about the human difficulty. For a moment, try to imagine this. Yamunabai may have gone through a ceremony. She may have believed herself to be a wife. But legally, because of the subsisting first marriage, the second marriage did not confer to her the status of a wife. The case of Yamunabai aptly explains that section 5 subclause 1 is not an abstract rule. It is a provision that affects status of a husband or a wife. It even affects the maintenance claim and legitimacy of children. Now let us move to the popular case of Sarla Mudgal versus Union of India. This case raised a different question around bigamy. The question was, what if Hindu husband does apostasy? That is, if Hindu husband converts to Islam and then contracts a second marriage without dissolving the first Hindu marriage. Bigamy is disallowed in Hinduism, but not in Muslim law. In Muslim law, it is legally permitted to have up to 4 wives at a time. For a Hindu husband, can conversion become a legal escape route? The Supreme Court said no. The Hindu marriage solemnized under the Hindu Marriage Act can be dissolved only according to Hindu law. Mere conversion of one spouse does not automatically dissolve the first marriage. So if a Hindu husband converts to Islam only to marry again while the first marriage is still subsisting, the second marriage cannot escape the provisions of Hindu Marriage Act. The message in Sarla Mudgal judgment is that personal laws cannot be picked and chosen by personal convenience or to evade the existing legal obligations. Yamunabai case shows us that for wife to secure maintenance under 125 CRPC, she must prove her marriage and she must fulfill the essentials of Hindu marriage. Sarla Mudgal case, on the other hand, shows that conversion from one religion to another is not a shortcut to dissolve the first marriage. Now, let us move to section 5, subclause 2, that talks about mental capacity. When we say mental capacity, section 5, subclause 2 expressly defines three situations of mental incapacity. The incapacity must be legally recognizable. For this purpose, there are three ideas inside section 5 subclause 2. Firstly, a party must not be incapable of giving valid consent due to unsoundness of mind. Secondly, the person must not be suffering from a mental disorder of a kind as to be unfit for marriage and procreation of children. And lastly, the person must not be suffering from recurrent attacks of insanity. Now we saw a bigamous marriage under section 5 subclause 1 is void under section 11. However, in case of mental incapacity under section 5 subclause 2, marriage is voidable under section 12. That means the marriage is not automatically null and void from the beginning in the same way as a marriage violating subclause 1 that we already saw. A useful case here is that of Alka Sharma versus Abhinesh Chandra Sharma. In this case, the husband sought annulment, alleging that the wife suffered from schizophrenia at the time of marriage and she was unfit for marriage as well as for procreation. The court examined whether the allegations were true and whether the allegations were within the meaning of mental disorder under Hindu Marriage Act. The judgment discussed that mental disorder must be of such a degree that it affects the ability to discharge marital and family obligations. Now let us come to age. Section 5 subclause 3 says that bridegroom must have completed 21 years of age and bride must have completed 18 years of age at the time of marriage. Section 5 subclause 3 must also be read together with POCM Act, that is Prevention of Child Marriage Act 2006. There is a common misconception even among several practicing advocates. The misconception is that a marriage of a minor is generally voidable at the option of contracting party, means a child who is minor at the time of marriage. But this is not the current view. There are certain aggravated circumstances mentioned in POCM Act where the child marriage may be void ab initio. POCM Act lays down two specific sections. One is section 12 and another is section 14 where marriages are void ab initio. I will not go into details of it and explain both of these sections because that is not the purpose of this lecture. We are not studying POCM Act. But you should know that POCM is a secular act, means it protects all children of India irrespective of their religion. I will discuss in more details about POCM and these particular sections when we study Muslim law, and I will discuss there the case of Independent Thought versus Union of India. Now we will come to relationship barriers under section 5 subclause 4. So section 5 subclause 4 prohibits marriage within degrees of prohibited relationship unless customs or usage permits it. And section 5 subclause 5 prohibits Sapinda marriages unless custom or usage permits it. The policy behind this provision is to prevent marriages that are too close in relations. But notice these words, unless custom permits. This is where you must become very careful. Custom is not vague or a broad term. A family or community cannot simply say that this particular thing is our custom. Under law, custom or usage must have specific and precise meaning, as we already saw in our lecture on sources of Hindu law. In that lecture, we discussed that customs and usages are one of the sources of uncodified ancient Hindu law. we also discussed what are the requirements for something to be called as a customs. A custom must be ancient, continuous, uniformly observed since time immemorial. It must be certain, it must be reasonable, and it must not be opposed to public policy. The burden to prove a custom is on the person who is relying on the custom. Customs are important in marriage because customs may validate a relationship that would usually be barred by law. Example is certain communities in Maharashtra and Andhra Pradesh. It is actually culturally acceptable for a man to marry his sister's daughter. Means marriage of uncle and niece are legally valid custom in certain communities. Another example of such exception to degrees of prohibited relationship is from Jat community of Punjab and Haryana, where it is allowed to marry widow of the deceased brother. So you can see certain valid and legally recognizable customs can override the degrees of prohibited relationship. When it comes to effect of custom, it doesn't end here. The custom may also define the ceremonies by which the marriage is said to have been solemnized. When I say word Saptapadi, you understand that it is about 7 steps around sacred fire. But do you know in certain Sikh, that is Punjabi community, there is certain sect where they take 4 circuits around Guru Granth Sahib. Even in some Gujarati communities, they take 4 circuits around sacred fire. All these are valid customs since these communities have been following it since long time and they are legally recognized. Now let us understand Sapinda. Sapinda relationship can be best understood visually. On the father's side, the prohibited Sapinda range extends up to 5th degree in lineal ascendant. Whereas on the mother's side, it extends up to 3rd degree. The person concerned is counted as the first generation. So if 2 persons fall within prohibited Sapinda relationship, they cannot marry unless there is a valid custom or usage permitting such marriage. Now again, mark this key phrase, unless custom permits. Remember, custom must be proved. The court will not presume that a custom exists merely because a party says so. The burden of proof of custom is always on the party who is claiming its existence. Now let us take a moment to revise and build a mind map of consequences of breach of 5 subclauses within section 5. Section 5 subclause 1 talks about the rule of monogamy. It says that no marriage should take place when there is subsistence of first marriage. In such case, marriage is void under section 11. And marriage may also raise issues related to bigamy, which are given under section 17. Section 5 subclause 2 talks about mental incapacity. Its breach generally leads to a voidable marriage under section 12. Section 5 subclause 3 talks about age. Marriage is voidable under Hindu Marriage Act at the instance of minor child. But remember, it may even be void in certain aggravated cases under POCM Act, that is Prevention of Child Marriage Act. There are also some penal provisions given under POCM Act where people involved in marriage of a minor can be punished. Section 5 subclause 4 talks about prohibited relationships. Marriage within prohibited relationships are generally void unless custom permits. And finally, section 5 subclause 5 talks about Sapinda relationship. Marriage within Sapindas are also void unless custom permits. With this, we complete section 5. Easy, wasn't it? Now let us enter into second half of this lecture where I want to talk about ceremony. Section 7 says that Hindu marriage may be solemnized according to customary rites and ceremonies of either party. Notice the beauty of this provision. Although it insists on solemnization, Hindu Marriage Act is not rigid. It recognizes cultural diversity of Hindus. The act does not impose a single uniform Hindu ceremony for everyone, for every Hindu throughout the country. It recognizes diversity of customs. So, under Section 7, the key question is that whether the applicable rites and ceremonies were performed during marriage. If the rites include Saptapadi, then the marriage becomes complete when the seventh step is taken. But if the applicable customs do not require Saptapati in first place, like I gave the example of Sikh community, that in certain Punjabi communities, they take 4 circuits around the Guru Granth Sahib. It is a valid recognized custom and it has legal force, and therefore people belonging to those communities can eliminate Saptapati from their marriage. Now let us focus on Saptapadi. As we already saw, Saptapadi is common but not always compulsory in every Hindu marriage. If the parties themselves accept that their form of marriage requires Homa and Saptapadi, and there is no proof that these were performed, then the marriage may fail the legal test. But where a valid custom exists or a state amendment provides for a different form of marriage, the court may examine or give an exception. So, when you are asked to comment about Saptapadi from the point of view of law, you should say that Saptapadi is not always compulsory. It is required only where the applicable rights include it. Saptapadi is important where the applicable rights include it, but it is not always mandatory. This one sentence can save your answer from being legally inaccurate. Now, we already discussed the case of Doly Rani versus Manish Kumar Chanchal in our last lecture. So, I'll not go into the principle behind it, but I would like to discuss the facts of this case so you will get a better picture of why the court had held so. The plaintiff and defendant, both of them, were trained commercial pilots. They had engaged to be married in March of 2021. They claim to have solemnized their marriage in July of 2021, and they obtained a certificate from an entity called Vadik Jan Kalyan Samiti. On the basis of that certificate, they obtained a registration certificate under the Uttar Pradesh marriage registration rules. But here is the twist. The families had actually fixed the date for performance of Hindu marriage ceremonies around October of 2022. Before that ceremony could take place, dispute arose between both the parties. FIR and court proceedings followed. When the matter reached the Supreme Court, the party admitted that there was no actually Hindu marriage ceremony. No custom, rites, or ritual had taken place. So the court asked a question: can a certificate create a Hindu marriage where Section 7 solemnization has not taken place? The answer was obviously no. What was the rationale of the apex court behind this judgment is well explained in the previous lecture, so you can go back and watch. So without risking further repetition, let's move on. Now we turn to proof of bigamy. This topic at first looks that it is at the perfect cross junction of civil law and criminal law. Let us begin with the case of Bhaurao Shankar Lokhande versus State of Maharashtra. Bhaurao was already married to Indubai. During the lifetime of Indubai, he allegedly married Kamlabai as well in year 1962. He was prosecuted for bigamy. Now, what happened at the alleged second marriage? The evidence showed that wooden sheets were placed, a carpet was spread, and the parties sat. Some puja was done garlands were exchanged, and the foreheads of the parties were touched together. The prosecution argued that this was a Gandharva form of marriage modified by local custom. Gandharva marriage means an ancient Hindu form of marriage about which we will discuss later in this lecture. So the Supreme Court said where a marriage is alleged, it must be shown that it was solemnized with proper ceremonies and in due form. Merely going through some gestures with the intention of being treated as a marriage is not enough. The prosecution failed to prove that the essential ceremonies were performed. It also failed to prove that the essential ceremonies had been validly abrogated by the custom. So the bigamy conviction could not stand. So the point that we learn from Bhaurao Lokhande case is that in allegations of bigamy, the law does not punish unless the second marriage has been proved, and it has been proved that the second marriage was performed with valid ceremonies and customs. Next, I'll explain the case of Kanwal Ram versus Himachal Pradesh administration. In this case, a woman named Kubja was alleged to have married Kanwal Ram while her earlier marriage was in question. The conviction was based partly on admissions. The Supreme Court reaffirmed the principle that admission of marriage is not enough to prove bigamy. The court reasoned that marriage is not merely a statement. It is an event consisting of legal ceremonies. If those ceremonies are not proved, the fact of marriage cannot be proved. Hence, there cannot be a legal or criminal liability. Finally, we come to the case of Priya Bala Ghosh versus Suresh Chandra Ghosh. The facts of this case are that Priya Bala alleged that her husband Suresh Chandra Ghosh had married Sandhya Rani, and this marriage took place during the subsistence of the first marriage. The trial court convicted him relying heavily on the admissions made during and surrounding circumstances. But the appellate court and the Supreme Court emphasized that the prosecution had not proved the essential ceremonies, particularly where Homa and Saptapadi were accepted as necessary rites among the parties. So the Supreme Court refused to sustain the conviction. Now let us step back and see the principle of these three cases that we discussed related to bigamy. Bhaurao Lokhande case establishes that solemnization must be proved. Kanwal Ram case, on the other hand, tells us that mere admission of second marriage is not enough. Finally, the case of Priya Bala Ghosh tells us that when a strong suspicion case is there, proof of essential ceremonies is a must. Now, let us make things more complicated. What happens when state law itself recognizes a simplified form of marriage? This takes us to the case of S. Nagalingam versus Shivagami. Nagalingam had first married Shivagami in year 1970. That marriage was subsisting, and during that time, it was alleged that he married Kasturi somewhere in 1984. The place was Tamil Nadu, and the man was prosecuted for bigamy. The defense argued that Saptapadi had not been performed, so there was no valid second marriage. At first glance, one may think that the principle of Bhaurao Lokhande and Priya Bala, those principles must have obviously applied here in this case as well. But this time, the Supreme Court had something more to look at. It was the state amendment of Tamil Nadu's Section 7, which is read as Section 7A due to the amendment done by the state of Tamil Nadu. Now, Section 7A recognizes the so-called self-respect and reform marriages. Under Section 7A of Tamil Nadu, certain simplified form of marriage are recognized. Parties to a marriage may choose to solemnize it simply in the presence of relatives or friends and in one of the prescribed ways. What are the prescribed ways under this section? One is merely by declaration that each party accepts the other as a spouse. Second is by garlanding or exchanging rings or tying a thali. Thali means a decorative ornament, which is equivalent to what we call Mangal Sutra in north of India. So in case of Nagalingam, evidence shows that thali was tied and garlands were exchanged. The court held that because Section 7A applied, the absence of conventional Saptapadi will not amount to the denial of a valid marriage. This case is extremely important because it prevents us from overstating the importance of Saptapadi. So, making a generalization that no Saptapadi means no marriage, this generalization is absolutely incorrect. The law says, or rather, the law asks the question, was the marriage solemnized according to the law or customs which are applicable to the parties? If Tamil Nadu Section 7A applies, a simple marriage in presence of few friends and both parties accepting one another as spouse, that will also suffice. So, as a lawyer, if you are arguing Saptapati as a ceremony to make void a marriage, you are actually missing a forest or a tree. Now, let us briefly look at classical background. Now, let us look at some classical forms of marriage in ancient Hindu law. Traditional Hindu law spoke about 8 forms of marriage. 4 of them were considered as positive ones or approved ones, and 4 were considered as derogatory ones. From the name itself, you would realize that some are associated with a negative connotation and some are associated with a positive connotation. By name itself, you will understand. These are the names of all the types of 8 types of marriage. Now, it is not important to remember all these names. I just mentioned it because in the case law that we just discussed, we talked about the Gandharva marriage, and that's why I explained it here. These types of marriage are important from historical point of view, but you don't have to remember them. Remember that in today's time, court will always apply statutory law and not the ancient law, and hence the modern statutory law will always prevail. So to ensure the validity of a marriage, the test that the court will apply nowadays will be section 5 and section 7. This is important because in litigation, people sometimes use traditional language loosely. They say it was a Gandharva marriage. This is exactly what prosecution had done in Bhaurao Lokhande case, as we already saw. Now we come to section 17. Section 17 says that any marriage between two Hindus solemnized after the commencement of the act is void if at the time of such marriage either party had a husband or a wife who was living. It then applies the bigamy provisions. The text of the Hindu Marriage Act still refers to the IPC sections of 494 and 495. However, you must remember that in new criminal law, that is BNS, the corresponding bigamy section is given in section 82. Now, what is the function of section 17? Section 17 actually acts as a bridge. Section 5 subclause 1 gives the condition that no spouse should be living at the time of second marriage. Section 11 gives the civil consequence of this, that the marriage will become void if first marriage has not been dissolved. Section 17 connects that voidness with bigamy punishment. But remember the extent of proof required on part of the party making allegations of bigamy. Proving existence of a relationship is not enough. Cohabitation is also not enough. And as seen in Kanwal Ram case, even the admission alone is not enough for criminal liability. Firstly, there must be a valid marriage. Secondly, there must be subsequent marriage while the first marriage is still subsisting. Thirdly, The subsequent marriage must be proved as solemnized. And fourthly, because the first spouse was living and not divorced, the second marriage becomes void. And when this chain is completed, the criminal liability may follow. This chain is important because if any link in this chain fails, the prosecution story will entirely fail. If the first marriage is not proved, the chain fails. If the first marriage has already been dissolved through divorce, the chain will not sustain. If the second relationship is not proved as a marriage, the prosecution again fails. And if the ceremony required for the second marriage are not proved, the prosecution again fails. Now you already know that in Bhaurao Lokhande case, the prosecution failed because they were unable to prove the second marriage. Bhaurao's case is worth comparing with the case of Gopal Lal versus state of Rajasthan. In this case, the prosecution actually succeeded. Gopal Lal had a subsisting first marriage. He contracted a second marriage with Gopi. The prosecution led evidence of a custom known as Nata marriage, also called as Nata Pratha, in Rajasthan, which is prevalent among Teli community. The essential ceremony of that customs were proved by the witnesses. The court held that the second marriage was valid according to custom, and since the first marriage was subsisting, bigamy was made out. So the contrast is worth seeing. Bhaurao's case shows that custom is not proved. In that case, ceremonies are not proved and hence conviction fails. Whereas Gopal Lal's case shows us that if a custom is proved, means ceremonies are proved and therefore conviction will sustain. This is how evidence decides the outcome in cases of bigamy, and customs related to marriage often play a key role for both defense as well as the prosecution. Now let us revise all the cases that we have discussed so far and let's do a memory recall. Doly Rani case tells us that registration is not equal to solemnization. Registration does not prove a marriage. Solemnization, where required as a mandatory right, must be performed to complete a marriage. Bhaurao's Lokhande's case shows that bigamy, for bigamy to be proved, ceremonies or valid customs must be proved. Kanwal Ram lays the principle that admissions alone are not enough to prove a marriage. S. Nagalingam case perfectly breaks the common misconceived notion that Saptapadi is mandatory for a valid Hindu marriage to take place. Even simplified marriage without the bandwagon and in presence of a few friends and exchange of two garlands is sufficient for a valid marriage if prevailing laws allow to do so. Yamunabai case explains that second marriage is void under section 5 subclause 1 read with section 11 when the first marriage is subsisting. Sarla Mudgal case is a very important central case which talks about apostasy among Hindu men. Apostasy cannot be a route to bypass bigamy laws. Conversion of religion does not break free a person from the legal obligations of his original personal law. Finally, the case of Gopal Lal versus state of Rajasthan clearly establishes that if the custom and essential ceremonies are clearly proved, bigamy is inevitably proved. This is how you remember case laws, by the legal problem that each of them addresses. So now, before calling a marriage as a valid Hindu marriage, ask these questions in the same sequence. First, that are the parties covered by Hindu Marriage Act? Second, does either party have a spouse living? Thirdly, is the consent and mental capacity legally valid? Fourth, are the age conditions satisfied? Fifth, are the parties within the prohibited degrees of relationship? Sixth, are they Sapindas of each other? Seventh, If a bar exists, is there a valid custom permitting the marriage? And 8. Was the marriage solemnized under Section 7 according to the applicable rites and ceremonies? Ninth, if the registration exists, does it record an actual solemnized marriage or it is being used to replace solemnization? 10th, if bigamy is alleged, has the second marriage been proved as a valid marriage? This is the complete step-by-step checklist to ensure that a marriage is a valid Hindu marriage in the eyes of law. So do not jump to conclusions. Do not be convinced only by the documents and do not be misled by the admissions. Validity of a marriage may be a question of status, emotion, and societal outlook for a couple. But for we, the lawyers, it is a conclusion reached after applying the statutes to the facts. So now let us close. Today we saw that the essential of a valid Hindu marriage is a Titanic in itself that comprises of customs, statutes, and precedents. So by discussing these case laws today in detail with facts, I hope I have convinced you that you are now standing at the edge of an uncharted ocean while only holding a map of a single bay. The biggest takeaway is this. Section 5 tells us who may marry. Section 7 tells us how the marriage must come into legal existence. Section 11 and 12 tells us the civil consequences. And finally, Section 17 brings us to the question of bigamy. So I want to leave you with one final question. In modern India, where couples increasingly rely on certificates, photographs, destination wedding, online records, and social media announcements, should the law continue to insist on proof of customary solemnization under Hindu marriage? Or should legal status move towards more formal registration? This is not merely a technical question, it is a question about the relationship between law, religion, customs, evidence, and personal autonomy. And that is why Hindu marriage law remains so fascinating. In our next lecture, we will take the next logical step. Once a marriage fails the validity test, how do we distinguish between void and a voidable marriage? Because law, unlike computer or your smartphone, does not communicate in binary language of zeros and ones. Legal failure is never absolute. It is a matter of degree.